Okay, last and final case on the docket, ESLINGER versus Shields. Huh? Morning.
Good morning.
Right.
May it please the Court, my name is Tom Polton. I'm here on behalf of Sheriff ESLINGER. I'd like to reserve 5 minutes of my time for rebuttal. The threshold issue in this case, the overarching legal question in this case, is exactly what species of tort is the false imprisonment claim. Is it the intentional tort of false imprisonment, a la the Willingham case, or is it more like a negligence case having to do with the reaction of jail staff to the claim of Ms. Shields?
How did you plead it?
It was pled as intentional tort of false imprisonment by the plaintiff. But by the time we got to...
Actually?
Pardon?
How did they plead it?
They pled it as intentional tort.
Right, all right.
But by the time we got to jury instructions, if you read the way the jury was instructed, they were told that you needed to ask what would a reasonable jailer do under the circumstances. They were given approximate causation instruction. The judge had ruled earlier that the question was, and if you look at the verdict form, was the continued detention of Ms. Shields prior to first appearance reasonable? So it sounded in negligence, even though it was supposedly the intentional tort of false imprisonment. And of course, from the sheriff's...
Is there any reasonableness analysis in a false imprisonment?
Not traditionally, no, Your Honor. Under Willingham, if there is a facially valid warrant, the law enforcement community is to enforce that warrant. And of course, our argument was that the way that you enforce the warrant is to take Ms. Shields to a judge, which is what was done here, taken to the first appearance judge, and in fact it was the...
Well, an arrest warrant doesn't necessarily mean that you're going to take the person to the judge. I mean, they can post bond, they can waive first appearance, they can enter a plea of not guilty and waive first appearance. So that's not necessarily the case in every warrant.
Not in every warrant, but in this case, one of the warrants for Ms. Shields was a no-bond warrant. So she would not have been able to bond out of jail. She would have eventually gone to a judge, and she was taken to first appearance, which was in the view of the...
You can obviously waive first appearance. You can enter a plea of not guilty or whatever and not go to first appearance, so you're not brought before a judge.
Well, that's true, but I think that a person who's claiming that the warrant was issued mistakenly in the first place wouldn't be in that group of folks.
You wanted a jury instruction that said exactly that, and that's not necessarily the state of the law in terms of warrants and what warrants are designed to do.
Well, I think that our request for that jury instruction was intended to meet the plaintiff's instruction, which was the reasonableness instruction. Is it reasonable to keep Ms. Shields in jail when the clerical person on the jail staff has some doubt as to whether or not she's the correct person? Now, and I say that, I think that as a threshold barrier you have to understand there's two different ways this can happen. You can have a doubt as to whether or not you have the right person in custody under the warrant. That's the broader spectrum. That's the more common question. The smaller number of cases, I would argue, that would occur, and this is where Ms. Shields falls into, is the question is the warrant wrong in the first place? Which is what ultimately her case was, is that Charlotte County had issued warrants for the wrong person. Seminole County Sheriff's Office had the right person in jail under the warrants. And the question became whether or not the warrants were issued incorrectly by Charlotte County. If the case is viewed from a reasonableness perspective, like a negligence case, and you ask, well, is the jail staff's reaction to that development their decision that they believe
really your best argument is Willingham, right? Isn't that your strongest argument?
Our strongest argument on if you view it as a traditional false imprisonment.
We're not talking about the negligent strip account because you didn't raise that. So we're talking about the false imprisonment. Isn't Willingham your strongest argument?
Our position is that Willingham is legally indistinguishable. Now, if there is going to be some argument that this policy that the Seminole County Sheriff's Office has changes the outcome.
Because it creates a duty is the argument.
Well, that's their argument.
And there's no duty element of a traditional false imprisonment intentional tort.
Correct. And I think the reason for that is because there's in place a command from a judge to the sheriff to take Ms. Shields before a judge. And I understand there are circumstances where that won't happen.
See, I have a problem with that last point. For example, hypothetically, if when the jail personnel contacted Charlotte County, if they had gotten back and said, here are the fingerprints, okay, you have the wrong person, we withdraw our hold. I mean, your argument is, oh, no, we don't have a choice, we can't let her go, we have to bring her in front of a judge because this procedural rule says that. That just doesn't, is that really what you're suggesting? You can't let somebody go before?
Well, no, but but your question highlights then what is really the fundamental problem with the case if viewed as a reasonableness negligence type case, which is that there is no evidence of what Charlotte County would have done had they been contacted in this case. And part of the problem is, and this is undisputed, there were no fingerprints in Charlotte County to compare to Ms. Shields.
So you would agree that on the jury instruction issue, that jury instruction doesn't accurately reflect the law. You have no legal obligation to bring the person in front of a judge, and that's not, I mean.
Well, no, I wouldn't if you have the right person. Which is the situation here. The instruction from the warrant is to take this person, all the sheriffs are commanded, take this person before a judge. Now, certainly you can figure out ways that between the time a person is arrested and the time of first appearance, there are ways to avoid that. Bond, for example, although that's not a problem here because one of the warrants was unquestionably a no-bond warrant. The evidence was, in this case, that had the clerical staff from the Seminole County Sheriff's Office called.
When it appears as though there was an attempt to morph the case into some sort of a negligence action, did you lodge appropriate objections when, you know?
Yes, we've been having that debate all the way up until the time of trial. We were arguing Willingham from day one, and that is a facially valid warrant, and there was no question of that, and that as a result of that, there was no case. But the judge ruled prior to trial, the question that will be submitted to the jury is going to be whether or not the detention of Ms. Shields was reasonable. And it was kind of broken up to different periods. First the arrest, then the period between the time jail staff decides they believe she's not the right person, and then, of course, the time from the first appearance judge's release of the hold until she's actually released. What I want to emphasize, though, is that the evidence was that had Seminole jail staff called Charlotte County, they would have been told the exact same information, except the only addition would be we don't think she looks like the photograph from the third-party website, the Department of Corrections website. And that's where the case ends. There was no evidence from the plaintiff as to what the reaction would have been at Charlotte County. And to analogize to a medical malpractice case, a la Gooding, if the claim is that the emergency room doctor doesn't refer the person who's come in with chest pains to a cardiac.
Are you saying that they call it a mandatory policy? You're saying that that's just totally irrelevant in this case? It means it has nothing to do with the issues of false imprisonment? As
the intentional tort of false imprisonment, that is correct, because that policy does not create the duty. The duty to investigate a claim from somebody that they're the wrong person on a warrant is a duty owed to the public as a whole. That's the same issue that came up in Willingham. There is no special duty created by that policy to a particular person. It's the public duty doctrine issue that you see in cases like Wallace v. Dean and whatnot discussed in those circumstances. I'm, however, forced to, we've got this situation here where the jury is instructed basically this is a negligence case. The trial court clearly viewed it that way, and so we were forced to defend on that basis. And so we're saying
if this were a negligence case, do you think that a duty of care and a standard of care can be established by one's own policy, or does it necessarily have to be some sort of a statute or regulation? Or well,
under Wallace v. Dean or Willingham or Pollock, it has to be either a special. It has to be the special relationship type duty. You could have a Wallace type duty, like an undertaking doctrine type case, but we don't have that.
Just having a policy, and we know what your policy is. If you breach your policy, does that constitute a form of negligence? Does that establish a duty of care and a standard of care?
No. Not under Pollock, not under Willingham. I mean, in Willingham, in fact, the argument was that it's not announced in the opinion what the policy was at Orange County or Osceola County jails. They held that gentleman for 5 days.
Willingham was a false, I think there's a clear distinction between the cause of action for false imprisonment and negligence.
Okay.
I'm just asking you based on, if this were a cause of action for negligence, we know negligence, a standard of care and duty can be established by statute, regulation. There are lots of ways, by contract. Can it be established by one's own breach of one's own internal policy?
Policy by itself, no.
Okay.
In fact, I think that's exactly what Pollock says, is that standing alone, in the absence of a pre-existing duty, that the policy would not create that. What I want to argue, point out, though, is on this causation issue, is that if you're, and really this even goes to the false imprisonment theory of liability, is that somehow, for example, probable cause evaporates, or reasonable suspicion to hold her evaporates when they decide she doesn't look like the picture. The person who can release the hold under their theory is Charlotte County. They didn't introduce any evidence that Charlotte County would have done that. In fact, the only evidence was from defense expert who said that typically she would sit there for a week or so until Charlotte County came and picked her up and resolved it on their end, that would be the more likely scenario. You can't count on a clerk in the middle of the night in Charlotte County to wave a magic wand and undo a judge's warrant either, based upon only somebody at the Seminole County Jail saying, well, yeah, she matches name, date of birth, social security number, all those descriptors, but we don't think she looks like a third party's photograph, the Department of Corrections photograph. That's not going to do the trick, and really it's their burden to introduce evidence that would have changed things if they're going to pursue it as a negligence theory, which is ultimately, as I say, I believe the way that the judge addressed the issue. With regard to the jury instruction issue, obviously our main position is that we were entitled to directed verdict or to judgment in accordance with the motion for directed verdict on the basis of the fact that there was a facially valid warrant. There was no dispute about that. But the plaintiff was allowed a jury instruction about negligence and reasonableness, and our position was that taking her to first appearance was reasonable as an alternative. And we were not allowed that instruction because, again, the judge was focusing on the reasonableness of jail staff reaction to the development where they decided that they believed her. And it was they that took all that information to the first appearance judge the next day and got her out. That was not disputed. So in the absence of evidence that it would have made a difference, even if it's a negligence case, our position is that we should prevail, and certainly our position has always been that Willingham forecloses this as a intentional tort of false imprisonment because there were facially valid warrants for the plaintiff. She got her out in less than 24 hours. Willingham, it took 5 days. Your Honors, unless you have any other questions, I really think I've covered it. It's a pretty simple case from our perspective.
Okay, you've got 8 minutes left, so
thank you.
We'll reserve that for you. All right.
May it please the Court. My name is Chad Barr, and I represent the plaintiff in this case, Ms. Kimberly Shields. I'm here today with lead trial counsel, Ms. Crystal Effort. This case has been brewing for 10 years now. Ms. Shields was first arrested in 2002, and this case has percolated through the system for about 7 years now. The benefit that you have on the panel this morning is that you have trial counsel. I was co-counsel at the trial level. Mr. Polton was trial counsel for the sheriff at the trial level. So we've argued this Willingham issue up, down, and sideways 10 times from Monday. So it's been distinguished.
If it's a false imprisonment cause of action, why wouldn't Willingham essentially decide the issue, decide the case? Why wouldn't Willingham be applicable here?
Our position with Willingham is that it's factually distinguishable and doesn't apply to these facts for the primary reason that in Willingham, all we know is that Willingham sued Orange.
Seems to me Willingham is more compelling than your case, to tell you the truth. I mean, Willingham, he had stuff right there when they arrested him that he wanted to show the officer, that it wasn't him, that there was someone had taken his identity. He ended up in jail for 5 days. I mean, it seemed to me like it's a more compelling case.
The interesting thing about the Willingham decision is that Willingham sued the officer who arrested him, right. And in the opinion, this court noted the officer didn't do anything. He exercised no discretion. He was then held by Orange County. All we know about his detention in Orange County is a sentence in the opinion. He was then transported to Osceola County. Osceola County conducted an investigation, and at the conclusion of their investigation, they released Willingham from custody. Osceola County was never sued in that case. So
Let me ask you this. Is this a cause of action for false imprisonment or is it a cause of action for negligence?
our cause of action was pled as a false imprisonment intentional tort claim.
Okay.
Our verdict form came from,
How did it, because it seemed to somewhat morph into some sort of a negligence cause of action, but, when I read all of this, I came to the conclusion this was a false imprisonment cause of action based on an intentional tort.
the verdict form in this case was actually comprised of the standard verdict form for false imprisonment claims, as well as a verdict form proposed by the sheriff in this case. And if you look at the verdict form they proposed and are arguing should have been used, it uses the same verbiage that we do. It's just the phraseology is just different. It uses reasonable, whether the detention was reasonable. First appearance was used in their verdict form. It's simply semantics.
All right, so you're saying that Willingham is distinguished. If we say it's not, that's basically the decision that we have to follow. If there is some distinction between this case and Willingham, explain, how you get to a legitimate verdict based on false imprisonment when the victim was picked up on a legitimate warrant.
And I think that's important too.
I'm having problems with that part of the case.
And I can appreciate that, and I'll be happy to address that. What we need to look at is the true distinction between Willingham in this case. In Willingham, we look at Orange County. All we know, like I said, is one sentence. He was detained by Orange County and then transported to Osceola County. In this case, we have jail staff who started to implement a policy and didn't follow through with the policy. So we have very distinct facts here.
How is that relevant to the intentional tort claim?
It gets us to the over the sovereign immunity. Essentially, what the theme of the defense has been is there's a warrant. We have sovereign immunity because we had no other. It was a duty that we owed to the general public to enforce this warrant. That gets to your discretionary sovereign immunity issue.
Willingham says there is no discretion. If it's a valid warrant, the officer has no discretion. I mean, that's what it said.
I believe that, and my reading was that the officer didn't exercise any discretion.
It said it has none. In other words, if it's a valid warrant, he can't decide. The officer has no discretion to say, well, gee, okay, you're not it, or whatever. I'll let you go. Well, it seems to say that they don't have that discretion.
And it's a little bit different when we look at the officer versus now we move to the detaining agency. In this case, the detaining agency, when she was first brought in, had no knowledge of who Kim Shields was. They knew she was brought in on a warrant. At some point, Kelly Brunell, who was the supervisor of booking and intake and release, said, I believe she was not the person who was wanted by the warrant.
What happens if Ms. Brunell became convinced this is the wrong person? But they've got this warrant from another county, and the warrant says pick this person up and hold the person. And they call the other county, and the other county says, well, we don't know that. We want the warrant. We want the person held. Then what?
Then we're not here. We're not here because at that point.
So I guess that gets back to the ultimate. What then does the policy have to do with the false imprisonment charge? So what if they followed the policy and they became convinced that this was the wrong person? You don't know whether the county that actually issued the warrant would have released her anyway.
Right.
And that's all speculation, right?
Well, yeah, it's an inference that, it's our opinion that it's an inference the jury was free to make. When the jury was faced with the proposition of, this is the person who was arrested, this is the person who was wanted. Two pictures showing two very different people.
Is that an inference or is that speculation?
I believe it's an inference that information having been provided to Charlotte County would have released a hold on Ms. Shields.
That's an inference. That sounds to me like it's speculation. You could have had someone from Charlotte County come and testify, I would assume. Did you have anybody?
There was no one from Charlotte County at trial.
All right.
So what we're looking at is a situation where they began to implement a policy. The policy was a mandatory policy adopted by the sheriff. The policy was not complied with.
Well, how do you deal with, even if it was a negligence cause of action, which again I have the same problem, it's not. But in a negligence cause of action, you'd have the duty element, but you have Pollock saying that an internal policy doesn't create a duty in the governmental tort context.
And that moves us into the Pollock decision. And Pollock actually says that policy standing alone does not. And I would agree with that.
There are instances where there could be something additional, but I mean, you know, you don't. What else do you have besides the policy? If we follow your argument, it's the policy, right?
Whether or not to implement the policy or whether or not to step into the policy is that discretionary level decision that sovereign immunity addresses. Once they begin to implement the policy, that's when it becomes an operational level judgment that sovereign immunity no longer applies.
It sounds like you're saying the policy alone creates a duty.
Yeah.
Once they begin to operate pursuant to the policy, they have a duty.
That's not what Pollock says.
I'm sorry?
That's contrary to what Pollock says. Pollock says the policy alone doesn't create a duty in the governmental tort context.
Actually, Pollock says that the decision whether or not to step into the policy and begin operating pursuant to the policy is a discretionary decision. Once you begin to operate under the policy, you then have a duty to comply with the policy, to reasonably comply with the policy. That's what Pollock says. Pollock doesn't just say that if you can't ever rely on the policy. There's plenty of decisions, and they're cited in Pollock, that show that there is a duty that's established by stepping into a policy and beginning to operate pursuant to the policy. So I believe that those cases are distinguishable from Pollock.
Anyway, your only argument is that the policy is relevant to intentional tort or false imprisonment, because we're not talking about negligence here anyway. There is no negligence cause of action here, right?
Agreed.
So we have to determine, is this policy, and whether the policy was followed or whether it was breached, relevant to a false imprisonment cause of action.
Right, and whether it's
based on a valid issuance of a valid warrant.
And whether it's relevant to and it's relevant because of their claim that sovereign immunity bars this cause of action.
Did you make any argument that the warrant was invalid?
Our position is that the warrant wasn't for Ms. Shields. The warrant was for someone else.
Did you make an argument in the trial court, and did you make an argument in your briefs that the warrant was invalid?
Respectfully, I'm not sure what you mean by invalid.
Well, I mean, it was just an improper warrant. It wasn't properly executed, it was.
Oh, it was on its face.
On its face. I mean, it's just an invalid.
That's not disputed, I don't think.
I don't believe so. Once they brought her in, at some point though, and as Judge Simmons noted, at some point they knew they had the wrong person in custody. And
well, I mean, they actually had the warrant was for Ms. Shields. I think that was the problem. Is that someone used her identity, and so they had Ms. Shields' identity when they did the warrant. It was for Ms. Shields. It just shouldn't have been, because the person who actually committed the crime was pretending to be her.
And that's not what we call an invalid warrant for purposes of false arrest, is it?
No, and I'm not making the argument that it was
okay. I just wanted to
invalid warrant. I just think at some point Seminole County knew they had the wrong, that the person that they had in custody was not the person who was actually wanted on the warrant. And so, therefore, they had...
If that's the case, and the warrant was for this specific person, and on its face the warrant was a valid warrant, then the decision whether to release that person would have come from Charlotte County, right?
Right, and then there's policies...
That wasn't a decision that the sheriff here was supposed to make, was it?
I disagree, and I think it's because the sheriff had an affirmative duty in their policy, and by virtue of stepping into the policy to comply with it and contact Charlotte County and notify them, hey, listen, we've got two people here, two very different people.
You're back to the policy again as being the sole argument that you're hanging your hat on.
And I apologize if I'm not making it clear. What I'm saying is, just because there's a policy doesn't mean there's a duty. Once you begin to operate pursuant to the policy, there becomes a special duty, a special relationship between the actor and Ms. Shields, the sheriff and Ms. Shields in this case.
Here's the bottom line for me. The problem I'm having is that, we know we have a valid warrant on its face. It's for this individual. The sheriff takes this individual into custody. There may be some suspicion on the part of some of the people in the sheriff's department that whether this is the right person or not, or whether this person's identity has been stolen, whether something has happened on the end in Charlotte County to make a problem with holding this particular person. But it seems to me it's the Charlotte County authorities that issued the warrants, and it's their responsibility to determine whether we're going to lift the hold and recall the warrant, or we want the warrant in place. And for false imprisonment, all this sheriff did was just pick the person up in accordance with a warrant from another county, and there was no attempt on the part of the plaintiff in this particular case to get any testimony from Charlotte County as to what they were going to do or what they would have done.
And I agree with you.
And that's the problem I'm having here.
And their policy specifically says that if we contact the county and we contact the Charlotte County and they wanted the hold in place, then it's on them now.
And I guess the disconnect that I have, the problem I have, is that if the theory is that there's a duty that attaches once they decide to implement this policy, and there was a breach of the duty because they didn't act reasonably, then that's not a false imprisonment claim at all. That is an independent negligence claim, and that's not what was pled or pursued.
Well, I guess it's again, the issue that was presented to the jury was whether or not it was reasonable to detain Ms. Shields beyond the point where they realized that they had the wrong person in custody. And the jury instruction, which was not objected to, says that failure to follow...
Were the jury... I mean, I thought there was an argument all along. They said that there was an argument all along that this was a false imprisonment claim and these issues shouldn't be tried in this fashion. Is that not correct?
I don't 100% agree with that, and I'll tell you why. There was a jury instruction that was presented unobjected to, which says that with regard to Ms. Shields' claim that the sheriff unreasonably detained her prior to first appearance, the plaintiff contends the jail staff did not follow certain internal procedures. If you find that a violation of the internal procedures occurred, that is evidence of unreasonableness. So it's our position the sheriff was trying to morph this into a negligence claim in order to kick it out altogether. We pled this as an intentional tort. They knew they had the wrong person. There was a policy in place that allowed them to get her out. In fact, their own expert testified that under these facts, there are only two ways for her to get out, in his opinion. Contact Charlotte County to have the holds dropped or take her to first appearance. The jury was presented with those two scenarios. Which one was proper? Should we have let her contact Charlotte County to let them make the decision, or should we have held her to first appearance? And that's what the jury was presented with, and that's the decision that the jury was entitled to make, and that's the decision that the judge felt that he shouldn't take away from the jury.
What was the testimony that they actually knew that they had that this person was the wrong person?
Ms. Brunel testified during her testimony that it's funny because
I think she testified that she was suspicious, or that she thought, or that she had some doubts. But did she testify? I know for a fact. For a fact.
She said, "I knew that we had the wrong person."
Huh?
She said, "I knew we had the wrong person," is what she said, and her testimony begins in the mid-100s of the trial transcript. But then, Mr. Polton will get up there and ask her a question, and then she'll waffle back and forth, and say, "Well, yeah, I knew, but I couldn't have done any. I couldn't have gotten her out." But it's completely contrary to what the policy actually said. So, unless there's any other questions on that, on point one of the appellant's initial brief, I'll just briefly address the jury instructions. And I think that the panel picked up on the fact that the jury instruction that was requested by the sheriff in this case is improper. It's a cocktail jury instruction from a bunch of rules of criminal procedure that don't really address or adequately address the situation that we have before the court today. And they have not shown that the jury instructions that were submitted were improper or misled the jury. So we would ask that the court affirm on all grounds raised by the appellant in this case. Unless there are any other questions, I'll pass it back off to Mr. Polton.
Okay, thank you.
It sounds like the argument is that you tried by consent a negligence cause of action, or alternatively, why don't you address that?
Your Honor, we argued from the very beginning, motion to dismiss, multiple motions for summary judgment, pretrial motions in limine, that this was foreclosed by Willingham because there were facially valid warrants. There's a discussion, if you want to look at it, at page 157, beginning at page 157 of the trial transcript.
The issue was never raised that this was a negligence case tried by consent. That's not an issue that's raised in this appeal.
Well, but I'm addressing, counsel's sort of implying that we did that because we didn't protest the jury instruction. The problem was that the judge had already ruled this was going to the jury on the question of reasonableness of the reaction of jail staff. We had argued that for 5 years unsuccessfully.
Opposing counsel says that there was definite testimony that I forget the lady.
Kelly Brunel.
Yeah, knew that, she knew, and the sheriff's department knew that this was the wrong person, and they knew it.
I respectfully disagree. The nuance is this. She testified that she believed Ms. Shields' claim that the warrants were wrong, but she did not think that the warrants weren't for Ms. Shields. That has always been the problem, okay, is that the warrants were incorrect to begin with, but they were for Ms. Shields. To put the onus on a clerk at the Seminole County Jail to undo a warrant out of another county at night, prior to first appearance is just not reasonable, and taking her to first appearance is what that mechanism is there to do, and they're the ones who got her out of jail. Counsel talks about the duty that stepping into the policy is what creates the duty, and he draws the distinction between operational and discretionary. That is the classic problem of confusing duty with sovereign immunity. You see it in the Wallace decision from the Florida Supreme Court. The first question, is there a duty? Then you ask the question whether or not it's sovereign immune and it's discretionary or operational. Pollock says that the policy standing alone doesn't create a duty. They have no evidence that a duty was created. Okay. And even if they did, they have no evidence that following through would have changed anything. Your Honors, unless there are any other questions, I think that really addresses the main issues on appeal.
Thank you. Thank you. Well argued on both sides.